Okay, good morning. This is the time and place for the Planning Hearing Officer meeting for November 18th, 2015. My name is Vilia Zamaitaitis, and I will be conducting the hearing as hearing officer. We have one case on today's agenda, and the relevant exhibits are posted on the bulletin board directly behind me. The hearing will proceed as follows. I'll read a description of the application request. The case planner will make a brief overview of the case, give analysis, and make a recommendation. The applicant will be asked to come forward, stating both name and address, and will be asked to present the case within a 15-minute time limit. Others in support or in opposition to the project will be asked then to come forward and speak, again clearly stating both name and address within a 3-minute time limit. Lastly, the applicant will be given the opportunity to make closing comments if desired in response to the testimonies given by preceding speakers. The hearing will be closed and the case taken under submission. Today's case involves a variance. So under the provisions of Title 30, Chapter 30.43 of the Glendale Municipal Code, a variance shall be granted only if all 4 of the required findings are present. If the evidence presented in the application and at the hearing meets the criteria just described, then the planning hearing officer can either approve or impose conditions of approval on the case in question. If the findings of fact are not evident, then the request must be denied. Notification of this hearing was accomplished by the use of public notices, which were mailed to the property owners located within 500 feet of the subject property, physically posted on the site in question, and placed in the local newspaper. After the hearing, the decision will be prepared in writing and will be in the form of a letter sent to the applicant and to all persons who responded to the public notice, either by speaking at this hearing or by submitting written responses and having provided their name and mailing address. The date of the decision will be the date appearing on the letter. And under the appeals provision of the Glendale Municipal Code, the decision may be appealed to the Planning Commission within 15 calendar days of the decision date. Anyone wishing to appeal may obtain the forms and brochures on the procedures from the Building and Safety Section, Permit Services, located on the same floor of this building. And again, if you wish to speak, please write your name and address on one of the speaker cards provided at the table by the front door and submit it to staff. I would also like to inform everyone that the official proceedings of the planning hearing officer's hearing are recorded on tape as part of the public record. Okay, so today's case is variance case number PVAR 1519116, located at 55 North Brand Boulevard. The application is to allow a 13 square foot accessory wall sign at the ground floor where the tenant occupancy is not located on the ground floor or second floor. It's actually located on the 14th floor. And again, the project is at 550 North Brand Boulevard. Ms. Asp, would you mind giving a staff presentation, please?
Sure. Thank you, Hearing Officer Zamaitaitis. The applicant, as you stated, is requesting approval to allow the installation of 13 square foot accessory wall sign on the ground floor of an existing building where the tenant occupancy is not located on the ground or second floor. Hutchinson and Bloodgood LLP is located on the 14th floor of a 21-story building. The wall sign is proposed on the ground floor arcade portion of the building, facing Brand Boulevard. As I stated earlier, it's 13 square feet and located approximately 15 feet above the ground with no proposed illumination. Hutchinson and Bloodgood LLP is the proposed copy with individual stainless steel letters attached directly to the building. The city's zoning code outlines that for each ground floor or second floor occupancy of a building, an accessory wall sign shall be permitted on each wall which directly faces a dedicated street, dedicated alley, mall, or parking area. The existing building where the sign is proposed has 195 feet of frontage on Brand Boulevard and has 3 ground floor occupants, City National Bank, Opus Bank, and Provident Lending Group. When we apply the findings, the variance findings to this case, starting with finding A, strictly applying the accessory wall sign standards in this case would not result in an unnecessary hardship inconsistent with the general purpose and intent of the ordinance. The intent of the sign ordinance is to create a more attractive business climate, enhance and protect the physical appearance of the community, and to encourage the most appropriate use of land. Further, it's intended to reduce advertising obstructions that may contribute to traffic accidents, reduce hazards that may be caused by signs overhanging or projecting over the public right-of-way, provide more open space, and curb the deterioration of the community environment. The subject site is located in the Gateway District of the Downtown Specific Plan. It's characterized by high-rise development with numerous corporate headquarters and businesses in multi-story towers. High-rise office towers house multiple businesses, and allowing all tenants to have a wall sign would be impractical and create unattractive sign clutter, which would be counter to the intent of protecting the physical appearance of the city regulated by the sign ordinance. And even though the focus of the Gateway District is to continue promotion and location of corporate headquarters, and Hutchinson and Bloodgood is a significant occupant or a significant tenant occupying the entire 14th floor of the building, signs for tenants at upper floor levels with no ground or second floor occupancy are contrary to the intent of the sign ordinance. For variance finding B, there are no exceptional circumstances or conditions applicable to the property involved or the intended use or development of the property that do not apply generally to the property in the same zone or neighborhood which warrant granting a variance for a wall sign. The size and scale of the 21-story building at 550 North Brand Boulevard has no unusual condition compared to similar surrounding buildings. Hutchinson and Bloodgood is an accounting and consulting firm situated in a high-rise building located in a section of the city with numerous other similar offices and businesses that do not have accessory wall signs advertising their businesses. High-rise office towers house multiple businesses, and again, allowing tenants to have a wall sign would be impractical and create unattractive sign clutter. The nature of business at an accounting and consulting firm is generally characterized by customers, serving customers with scheduled appointments for staff to meet with their clients. This is dissimilar to restaurants, retail, and baking establishments that often rely on foot traffic and the convenience of a ground floor location to serve their customers. Additionally, the sign code allows for other types of signage besides an accessory wall sign. These include an identification sign and a high-rise wall sign, which this tenant would be eligible to utilize. Finding C, the granting of an accessory wall sign variance would not be materially detrimental to the public welfare or injurious to the property or improvements in the DSP Gateway District. A non-illuminated 13-square-foot accessory wall sign is a minor proposal, and the location and scale of the proposed sign at the ground floor of a building is appropriate. Although there are only 3 accessory wall signs at the ground level currently, ground floor uses can fluctuate in size, and depending on the changing nature of the uses in their business, should another tenant locate on the ground floor, the available space for an accessory wall sign could be eliminated if a sign variance for the 14th floor is granted. And finally, finding D, granting of the variance will be contrary to the objective of the ordinance. As I stated earlier, the objectives of the city sign ordinance include creating a more attractive business climate, enhancing and protecting the physical appearance of the community, and encouraging the most appropriate use of land. And while wall signs in particular help ensure building walls do not contain an overabundance of signs, that thereby preserves the physical appearance of the community. The Hutchinson and Bloodgood accessory wall sign at Brand Boulevard would be in addition to the other wall signs on this building. The sign, as I stated earlier, is in proportion to the size of the wall that it will be placed. But with that said, signs for tenants at the upper floor with no ground floor or second floor occupancy are contrary to the intent of the sign ordinance. So with going over those 4 findings, staff was not able to justify all of these 4 required findings and recommends that the request be denied. So I'm available for any questions.
Thank you, Ms. Asp. No questions at this time. I'd like to invite the applicant to the podium, Mr. Peter Weir. And you have 15 minutes.
Good morning.
Good morning.
Planning Hearing Officer Zematitis, pronouncing that properly. Thank you for your time this morning. Appreciate all the efforts that have gone into this, both from staff. Obviously, this is a very important issue to Hutchinson and Bloodgood, being the city's second oldest business, having been founded here in 1922, and a location on Brand Boulevard in different locations, but having been located on Brand Boulevard that entire time. Just a little bit about the firm. Hutchinson and Bloodgood's a regional accounting firm. We have 4 offices, and we're headquartered here in Glendale. Just in terms of overview, building ownership, we've been at this now for about 2 years. We moved in 2 years ago next week. Building ownership has been very supportive of our desire for signage. There are provisions for that in our long-term lease, and so they are willing to support whatever needs to be done to make this happen. So as has been pointed out, the signage is in line with existing signage on the building in space that has been previously approved for signage. And in fact, there are other non-ground floor or first floor tenants with signage in the panels that we're all discussing. So with that, the signage is about 13 square feet in size. It's designed to fit perfectly into one of the 3 remaining blank panels that are on the building. I think it was mentioned that there were 6, so there are 3 existing. It's in line with other existing signs: long-term tenants, City National Bank, Opus Bank, and Provident Lending. Does not stand out any more so than any of the rest. It's not lit. And is fabricated of a similar stainless steel material that matches some of the other signage on the building. We realize there are other first floor tenants, and they occupy the entire first floor, so there's no additional required signage requirements at this time. We do understand, as has been noted, that signage and tenants, or particularly tenants and tenant needs, change, although the current makeup is such, and given the length of our lease, we don't see that changing anytime soon. Second floor tenant is an investigatory agency for the federal government, ATF, and due to the covert nature of their investigations, they're not going to be requiring signage anytime soon. So with that, Finding A states that allowing all tenants to have a wall sign would be impractical, create unattractive sign clutter, which would be contrary to the intent of protecting the physical appearance of the city as regulated by the sign ordinance. This suggests the spirit and intent of the variance process, and it's not been considered at all, and in each case needs to be weighed on its own merits. The signage that we're proposing is the signage that I believe the city is intended to promote, but the strict adherence to the law here, if you will, is going to prevent that. Signage is designed to go in a place that's previously been approved by the city for signage in such buildings. So we're not doing anything in a location that would not otherwise have signage on it. It's not on a post. It's not in what would be considered an annoying location. Finding B states that there's no exceptional circumstances or conditions applicable to the property and reiterates in draft finding A with respect to all tenants. Does not take into account the fact the signs we propose were anticipated in the development of the building, and accommodation made for the building's facade design was for such signs. A high-rise sign, as suggested in the staff report, would be intrusive and unnecessarily huge. It's certainly not anything that we were looking for as we negotiated our lease with the building. We're not looking for rooftop signage. We're just looking for simple signage at the street level to let folks know where we are. Additionally, the draft findings suggest that the nature of the business as an accounting firm and not a bank or restaurant would not warrant the placement of the sign as proposed. However, this suggestion is based only on the opinion that, we aren't a restaurant and we're not a retail establishment. However, we do have visitors on a daily basis. We take deliveries. As with any other business, having a sign noting our location would be helpful and certainly business friendly. Finding C recognizes that the accessory wall sign as proposed will not be detrimental in any way, is not illuminated, does not contribute to the overbearance of signs, and that the size and scale is appropriate. Concern was raised about potentially future tenants needing signage. And back to my earlier comment, we would expect that, well, first of all, our lease calls for signage in this location. So to the extent that the building ownership had a potential tenant that needed signage, that would be something they'd have to take up with them and then take up with us. Secondarily, if it was an issue, it would be something that could potentially be the building could covenant that in the event they had a changeover in tenants on the first or second floor, that there would be some inducement for us to take our signage down and therefore meet the requirement of the first or second story signage condition. Finding D states that the sign will be in addition to other signs on the building in proportion to the size of the wall on which it will be placed. Placing a well-designed, high-quality sign on one of the three remaining faces would not be contrary to the intent of the sign ordinance. As staff points out, the objectives of the sign ordinance include creating more attractive business climate, enhancing, protecting the physical appearance of the community, and encouraging the most appropriate use of land. Wall sign standards in particular help ensure building walls do not contain an overbearance of signs, thereby preserving the physical appearance of the community. Focus of the Gateway District is to continue promotion and location of corporate headquarters. Hutchinson of Bloodgood's is a significant tenant. We occupy 18,469 square feet in the building, which encompasses the entire 14th floor. The building fronts along Brand Boulevard, and the signage, total signage space spans 191 square feet. Our proposed sign would cover 13 square feet. It's also important to note that information about the variance case was sent to over 850 property owners, tenants, and occupants within 500 feet of the building, including all occupants of 550 North Brand. The sign was placed in front of the building where thousands of people walk by on a daily basis, see it, and to my knowledge, no one has weighed in adversely on this proposed variance. In addition, typically 14 city departments receive hearing notices, and again, we're not aware of any expressed concern. Codes are a guide. Rules recognize that there will be instances where the code does not work to achieve the desired objective of the community. The variance process is a tool that can be used when one size does not fit all, and we would expect it to be applied on, fairly on a case-by-case basis. We feel that this is such a case. We would urge your approval of the variance request and appreciate the city's support on this. Thank you.
Thank you, Mr. Weir. I have a speaker card from Mr. Bill Boyd. Please.
Thank you very much. Bill Boyd, 100 West Broadway, Glendale, California. I'm speaking just as an interested party today, and by background, it's been my pleasure since 1981 to have leased 10 of the city's major 14 office buildings. I had the pleasure of leasing this building originally in 1987 and following its development and its approval through the city process. And those panels that Ms. Ass referenced behind you on the picture there are 6 of them that were planned for office tenants in the building. And what I think is most important is, as I was sitting here listening to both the report and to Mr. Weir, I believe as an interested party, both sides are correct. I understand the policy and the intent of what's been done, especially to prevent, all due respect to our friends at 401 Brand with a golden Buddha and a cloth banner and fake balloons. Well, codes should prevent that kind of thing, I think. Maybe some people like golden Buddhas. Maybe not in an office building. So the intent that the developer had and the current owner has, which is Clarion, a major national landlord headquartered in Boston, has awarded Mr. Weir's firm this signage on their building that's consistent with the original intent of what the owner of the building always intended for its office tenants. We believe it's the right within reason and code of a landlord to grant a tenant signage, and mindful those ground floor tenants that are there do have illuminated signs. This tenant, as well as Morgan Stanley, who is a tenant also in the building with the same exact signage panel, is not illuminated. And as Ms. Ass pointed out, we don't expect anyone driving by to see the tenant sign and say, oh, let's go in and see them. But it is a concession in a lease, in a 10-year lease obligation that the landlord granted to this tenant to have this tenant sign on that building. And so I think this process is exactly what it should do, is to understand the staff is correct in the rules they've been given. But hopefully there might be some what I would consider common sense in historically what we do for office tenants within reason and tasteful and designed properly. And that would be it.
Thank you, Mr. Boyd.
Thank you.
Quick question, though, however.
Yes, ma'am.
You are representing yourself as an interested party, is that correct?
Yes,
and
ma'am.
you're not representing the leasing agent or the property owner?
I'm not authorized to represent Hutchinson. I represented Hutchinson Bloodgood in their lease with the landlord, so I'm intimately familiar with their lease obligation and what the landlord granted.
Okay, were you the leasing agent that established the tenancy 2 years ago, I believe?
Yes, ma'am.
Okay.
On the tenant side, landlord had its broker as well.
Correct. Now, in negotiation of the lease, obviously the signage came up. At that point in time, did anyone check with the city in regards to the sign standards?
No,
for wall
landlord was
signs?
relying on the historic information it had since it goes all the way back to 1987.
Okay. So there are 6 panels, and I understand, and I concur with you that those panels were intended for wall signage. In regards to the rest of the building, and you spoke about in terms of equity and whatnot, I'm just curious, what would be your opinion as an interested party with regards to the fact that this is a 21-story building? There are 19 other floors above the second floor ground occupancy, which would be allowed wall signs. In terms of wall signage for those other occupants within the other 19 stories,
Well, the landlord, much like any, in my opinion, good parent, simply says no. There could be a 3-floor tenant that requests signs in the future, and a landlord may or may not, or there may or may not be space that's remaining for a tenant. Just to beat this to death, there could be a 500-foot tenant that if they pay an exorbitant amount of unbelievable amount of rent for the right to have the name on the building, landlord would assume it has the right to do so, just given its historic understanding of what those panels were meant for. it's impractical. It will never happen. But
And again, if the landlord, I understand where you're coming from, but if the landlord promises, and in terms of the negotiation of this particular lease, was there any discussion with regards to a high-rise wall sign, which would be permitted by code, or an identification sign for Hutchinson and Youngblood, which would be permitted by code? Were those two options at all discussed at the time?
in that lease, you're correct in that lease document. Landlords, in my experience, in all leases we do here in Glendale or other buildings, put the onus on the tenant to go submit permitting, do what it has to do. It wants no part of the signage installation. It says, Mr. Tenant, that's your obligation. You do have the right. I give you permission to put it on my building. You go do all the legwork. So historically, and this is a surprise to the landlord also, when Mr. Weir went to the landlord and said, well, we have an issue here where we need to go through a variance process. The landlord is quite cooperative and said, okay, I'll sign whatever you want. I'll say whatever you need. And which might be, maybe, in your wisdom, the way to navigate this, if there is a way to say the staff report is correct, given what they have to work with. And if a landlord can covenant and say, well, this is what I've done for this tenant, I understand that there's no more room for any more space, or only if Opus Bank moves out, then maybe someone else gets it put in. So there'll be a way to do it. I'm just not smart enough to know how you do it.
Yeah. I really appreciate you coming
Sure.
and speaking on behalf
Sure.
of the case.
Thank you.
So, Mr. Weir, you're welcome to a rebuttal period. You may agree, disagree. You do have a rebuttal period if you like, and it's 3 minutes. So,
Well, I don't know that it's necessarily a rebuttal to anything Mr. Boyd has pointed out. Certainly support those points. But I would say that given the business-friendly environment in the city of Glendale, I think as has been pointed out, the intent of the code to mitigate needless signage, I'm certainly all in support of that. But again, I think that in this particular case, it's going to prevent the signage that was originally intended to be posted in a place that was appropriate for it. In addition, I think that the downtown plan in general needs to be, as it relates to the signage, needs to be consistently applied. And I think, as was mentioned earlier, in terms of the building owner's perspective on this, we all looked at the building and said, well, there's a 10th floor tenant with signage in this location. We'll put yours up right next to it. What's the problem? And so here we are today. So we would just ask that, you take another look at it, and would appreciate all your efforts on that. So thanks very much.
thank you. And we will look into the issue with regards to Morgan Stanley that was put up 2 years ago. So that will be discussed in not only the case file, but also in my decision letter. So, okay. With that said, I see no other individuals who wish to speak on the matter, and so I will close the public hearing and take the matter under consideration. Thank you very much.
You want to print it out?